It's what day is it? March 5th. We are back in court today for the Commonwealth versus Karen Read. There was much scheduling discussion at the end of the day yesterday about when argument was going to be in the motion to dismiss. And argument for the motion to dismiss is going to be today. As we got to the lunch break, we have learned new information. And that new information includes that there was an October report from Trooper Buchanan that indicated that in May 2024, during the last trial, he was reviewing video with ADA Lally. But the video, or at least some of the video he was reviewing, were not turned over to the defense until October of 2024. So it was reviewed in May during trial and wasn't turned over to some 5 months later. What? We've also heard that the inverted camera, because apparently it was a defective camera from the inverted video, was removed and disposed of sometime between January 29th, 2022 and July of 2024. So no one can even examine what was defective about the camera to make that shit flipped. But it would make logical sense, which is not what the defense should have to go on. They should have the physical evidence. So should the Commonwealth. If the camera internal components or lens or whatever was recording things inverted, that would be a reasonable explanation for why the video was inverted, but the timestamp wasn't. You know what could answer that question? Having the camera. I bet somebody could look at it and tell you, or you could bring in someone from the manufacturer to explain. There's a lot of ways you can do that if you have it. But if it's been disposed of, there's nothing you can evaluate. Like the metadata. If the metadata was overwritten 30 days in, it's a problem. I think the best outcome from the defense here is that there has to be an evidentiary hearing to explain what videos were taken out of the system. How were they taken out of the system? When were they provided to law enforcement? Who knew? When did they know? When was it discovered? Where was there just like a disk or a thumb drive in a file some fucking where else in the police department that just got found? There needs to be a hearing. Put people on the stand, put them under oath, and ask them the questions. I don't see how any decisions are made on this motion without that. Because there are things that we keep going through that I'm like, wait, there's more. Wait, there's more. And we started off the day with the court getting really feisty with the defense over representations about what Lieutenant Fanning did or did not do with relation to the jury. And I'm really interested to hear more about that from the Commonwealth too. I'm interested in the two sides of that conversation because so much of it was redacted in the filings. But the court was not happy with the arguments made by defense and said to defense, what is your good faith basis for arguing this in your motion? Which pissed off Alan Jackson, and you could see it as he raised his voice in court saying,
just ironically, who knew he ends up being the source of the information that got that juror removed? That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that shouldn't have happened.
And so the issue with Lieutenant Fanning is going to come up again. Alan Jackson, as we got to the lunch break, says he has 45 minutes left. Are we going to get through everything that's supposed to be heard today? Maybe, maybe not. Because Alessi has stuff they need to argue as well. And there was a motion from Elizabeth Little. So will we get through all three motions? We'll see. But I think the best outcome for this motion to dismiss is an evidentiary hearing before any ruling.
And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos.
Scotty didn't know.
How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024.
And the prosecution thinks it matters too.
The Commonwealth claims that they received these videos on or about August 21st, 2024.
I'm sorry. You're telling me that the Commonwealth was made aware of the videos in August and turned them over in October? They have an ongoing discovery obligation. What are we doing? We know that this was a massive point of contention. I can understand taking a week to review them. I can't understand not turning them over till October.
They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote.
What?
LOL, laugh out loud. So the chief of police.
I don't have enough sounds on the soundboard. That's how it records LOL, no tampering. From the chief of police. New information was learned by us all today during the hearing for the Commonwealth versus Karen Reed. We heard a lot more with regard to whether or not there was any interaction with the jury. It's the thing that the court was coming in hot with questions about this morning for the defense. What jury interaction or non-interaction was there? And the court got after the defense saying, you put in your papers that Lieutenant Fanning had interaction with the jurors. What is your good faith basis for that argument? And at the end of that, the court said, I don't know if I'm persuaded. And then we heard Alan Jackson explain a bit further where their good faith basis was. By the time we get to the end of the hearing today, what we learn about a juror that was removed right before closing arguments was that Lieutenant Fanning, who was in charge of the security outside of the courthouse, seemingly operating remotely, was told by multiple individuals, per the arguments in court today, that there were rumors of a juror expressing an opinion on the case out at perhaps a private location, perhaps videotaped on that location or not. Alan Jackson said these were rumors that were passed to Lieutenant Fanning. We don't know who told Lieutenant Fanning that. We don't seemingly know when. And we don't really have a lot more information about that based on what was said in court. Because what the defense said is at the time we asked for a hearing about that, bring in Lieutenant Fanning and ask the questions, who told you this? Because then Lieutenant Fanning told a court officer, it seemed the court officer communicated it to the court or the Commonwealth, and it came up at a sidebar. The juror was questioned about it and denied it and then removed. And at the time, the defense asked for more information. Bring in Lieutenant Fanning. Who told you? How'd they tell you? And the defense argued it again in court. Who told Lieutenant Fanning? And how did they know to get in touch with Lieutenant Fanning? Were people texting him that knew him personally? Or did people go tap on his shoulder and be like, I think you might be involved in the Karen Reed case. And I think a juror in the Karen Reed case that somehow we know as a juror in the Karen Reed case might have done a thing or said a thing or been seen in a place. But the defense can't really argue more than that because there was no further inquiry. They asked the juror about it. The juror denied it. And then the juror was removed anyway. That's the argument with any communication about the jury and Lieutenant Fanning. And the Commonwealth's arguments were doubling down on Fanning's reputation and that Fanning is essentially unimpeachable and that Fanning didn't have any interaction with the jury. The Commonwealth didn't answer where the rumors came from and who or how many people communicated that to Fanning and how they knew to communicate it to Fanning. There are unanswered questions there. The main argument, though, for the motion to dismiss is the videos from the Sallyport. Was the defense given discovery that was exculpatory? When and how was it preserved? And did it get withheld? Ultimately, is there still evidence that is being withheld from the defense. And is that evidence exculpatory? And both sides were arguing this, the Commonwealth arguing that any videos from the Sallyport aren't exculpatory because there is other evidence showing the condition of Karen Read's taillight, and arguing that the videos from the Sallyport, the Commonwealth didn't even appreciate the import of those videos, and the defense never asked for videos from Canton PD, so how would they know? Now, that argument might have carried a little bit more water before the Commonwealth said in court that after the first trial, the member of seemingly Canton City, Colleen Crawford, this seems to be the tech person, went back to Canton PD, and lo, on the Canton PD DVR, there were still videos from January 29th, 2022. And at that point, more videos were taken off of the DVR after the last trial, so July-ish or after 2024. But when the defense expert went out in December 2024, there was nothing left on the DVR. It seems that the video on the DVR was preserved at least until after the first trial. That is a huge issue. And there was no clarification of when that video was accessed by Colleen Crawford or when it found itself no longer on an external hard drive connected to the DVR system. But we learned today that that video was not overwritten in 2022. And in fact, there was more. And the date is unclear because no one asked Attorney Brennan and he did not offer. But Attorney Brennan said, in fact, we went back, Commonwealth Canton PD, went back and pulled other video from the DVR from 2022, from January, to show that the inverted camera was inverted and the blurry camera was blurry. If it overwrites every 30 days, when did you go back in time and grab video from early January 2022? What date did that happen? And we learned from the defense today that in a report that was authored last week, that the retired detective was downloading all the video from the entirety of the time Karen Read's car was in the Sallyport, which was about 2 days. And there was so much video, it had to be downloaded in 6-hour chunks. And then we learn that at some point there was communication between that retired detective officer and the chief of police for Canton. And the chief of police from Canton said something to the effect of, and there was more to a note, this was part of a note that was retold in court by the defense and not disputed by the prosecution, that the chief of police said, the video is inverted, lol, no tampering, lol. We also heard that multiple rounds of video were picked up at Canton PD by Trooper Sergeant Buchanan and given to Trooper Proctor. And when the court questioned the Commonwealth about what detective file video was just found in, guess whose file it was just found in? Trooper Proctor's. And I would say that Trooper Proctor's file is not a detective file. Maybe this is me being picky. But generally, when it is the lead investigator, that would be referred to as the case file, not just a detective file. It's the case file. A detective file implies, and I think improperly implies, that it was one of the other individuals involved in this case that put it in a file somewhere. When it is the case handling agent or officer, it's the case file. So Trooper Proctor had the videos in a case file before the last trial. at least some of them. And those weren't turned over to the defense, some of them, until January of 2025. The videos are an issue. The law in Massachusetts is more difficult for the defense. The standard is more difficult for the defense than the standard in New Mexico, which is why the defense was arguing that this was bad faith, because then prejudice is presumed. It doesn't have to be proven. The defense has to show that it's irremediable. And I didn't hear a lot of argument either in the papers or from the defense that even moving the files off of that DVR alter it, because you lose all the metadata that shows when it was accessed and the rest of it. I think the defense's best outcome here, obviously they want this case dismissed, but I think there are questions about who touched the video and when that should be answered in an evidentiary hearing. I think it would protect the record. I think the case needs it. I think the defense deserves those answers. And I don't think the court is just going to dismiss it on the motions alone. I think there needs to be an evidentiary hearing to really get to the bottom of what's going on with this video and where is the rest of the video. Where is it? If there are 6-hour chunks that cover 2+ days of time, where are they? And I think the only people that are going to know are Trooper Proctor and the person who downloaded all of the video in the 6-hour chunks. Where's that person? And why is the chief of police lolling about, oh, the video's inverted? Oh, by the way, we also learned today that the inverted camera was replaced and disposed of sometime between January 2022, and like now. There was no real specific timeline, but at some point that inverted camera was replaced and disposed of. So it can't be evaluated, much like the phones that do all the butt dialing. There is so much that was learned today, in part because the defense is still getting new reports. And I think the reports that the defense got last week on Friday helped their motion to dismiss, and I think strengthened their motion to dismiss. I still think there's going to need to be an evidentiary hearing. I think the best outcome from the defense, though they want this case dismissed immediately, I think an evidentiary hearing puts them in a good position, A, if the court doesn't dismiss it, for a appeal down the road. I think it gives the court more information. And I also think it gives the court a clearer path to talk about how long Trooper Proctor had these videos. And I think that egregiousness can be highlighted better in testimony in court than just in written motions and argument. So I would like to see an evidentiary hearing to dive in to what the fuck went on with these videos. But the court first has to find that the videos are exculpatory. And if the court does not think that the Sallyport videos are exculpatory, then an evidentiary hearing is not going to be given because it ends the inquiry. If it's not exculpatory, the inquiry is over. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.